Hi, this presentation discusses Clearview AI's privacy concerns from the Haynes-Boone article. My main point is that the privacy failure was not only the size of the database, it was the chain of decisions around it, scraping images, converting faces into biometric identifiers, selling access, and allowing outside searches. I will cover 5 safeguards. Each safeguard names the responsible party. Some controls belong to Clearview because it collected and commercialized the data. Other controls belong to law enforcement agencies and private users because they controlled how the tool was searched and used. The Haynes-Boone article gives the case facts that drive the safeguards. Clearview allegedly built a facial recognition database from more than 3 billion scraped photos and sold access to more than 600 law enforcement agencies and private entities. The individuals allegedly did not know about or consent to the capture and use of their biometric data. A related claim alleged failure to give notice at or before collection. The article also notes that Clearview's client list was hacked. These facts point to 5 risk areas: source data consent, purpose, access, and security. The first strategy belongs to Clearview. Clearview should have built a data provenance and consent inventory before training or selling the system. For each dataset, it should document the source, collection method, biometric fields, consent status, privacy law, IP rights, retention rule, and permitted use. Johnston recommends inventorying all data used to train and develop AI documenting privacy consents. That control fits the scraped photo issued directly. It also supports Potsa's point about purpose specification when personal data is collected and later used in AI systems. The second strategy also belongs to Clearview. Clearview should have used notice, deletion rights, and purpose limits. In the Bird case discussed by Johnston, the allegation was that Clearview failed to inform consumers at or before collection about the biometric information collected and its purpose. A stronger process would explain the use, limit the data to that use, and give people a deletion path. Von Rijmanam connects AI privacy risk to opaque personal data minimization. This means transparency cannot be only a posted notice. It must control later reuse. The third strategy is technical and belongs to Clearview. Clearview should minimize biometric data and protect templates. It should avoid retaining raw facial images or reusable face features when a protected representation can support the approved function. Hu and colleagues explained that once facial data is sent to a service provider, users lose control over that biometric data. Their work supports controls that reduce reconstruction, attribute inference, and function creep. This would not solve non-consensual scraping, but it would reduce harm if biometric data were breached or reused outside approved purpose. The fourth strategy belongs to law enforcement agencies and private sector users. They should not treat facial recognition as a general search engine. Each search should require a documented case purpose, approved user case, and for higher risk searches, supervisor approval. The system should log the user, image submitted, purpose, result, and export. Logs should be reviewed for curiosity searches, bulk searches, and searches outside policy. This responds to the scale of Clearview's customer database. It also follows Potsa's point that AI controls must be applied to the specific tool and use case. The fifth strategy is shared. Clearview and its users both had security duties. The client list hack shows why privacy governance must include security governance. Clearview should encrypt biometric and client data, monitor privileged access, test controls, and maintain an incident response plan. User entities should restrict accounts, rotate credentials, remove users who no longer need access, and review activity logs. Both sides should define breach notice duties and post-incident suspension rules. Von Rijmanam emphasizes security protocols and audits as privacy safeguards, and that fits this case. This slide separates accountability by actor. Clearview should own the controls closest to collection and the platform, and these are data provenance, consent records, notice, deletion, retention, biometric minimization, template protection, platform security, and breach response. Users should own the controls closest to operational decisions, and these are case justification, access approval, query logs, misuse review, and human review before action is taken. This division matters because Clearview could not control every downstream decision, and users could not repair Clearview's original data sourcing problem. Privacy controls needed to follow the life cycle, and this is collect, train, sell, search, and act.